Our next speaker will be Professor Louis Wolff, and he's Dean and Wei Long Professor of Law at the Chinese University of Hong Kong. And he has written and published widely in this area, as well as all very interesting issues in Asia-Pacific area. So, Professor Wolff.
Thank you very much. Let me just share my PowerPoints. Okay, here we go. Thanks for the introduction and thanks for inviting me. It's a pleasure to be here to attend such an important symposium. Article 6, opting out, the opting out option for the CISG has been mentioned several times. And in fact, the Department of Justice in the consultation paper has raised two questions. Why would one choose to opt out of the CISG in sale of goods contracts between Hong Kong and non-Hong Kong parties? And what is the likelihood, that's the second question, of opting out of the CISG in such contracts if given the opportunity? I will discuss these issues in the second part of my presentation, but would like to remind us very, very briefly of the opt-out mechanics that the CISG provides. As a matter of principle, the CISG applies when the conditions for its application are met, and the legal basis, as mentioned very many times, for opting out of the CISG is Article 6, which provides, as Mr. Wong has brought to our attention, for two mechanics. First, a complete opting out of the CISG, and then a variation of or derogation from particular CISG rules. To opt out of the application of the CISG requires parties' agreement according to prevailing opinion. The parties reach a negative choice of law agreement at the conflicts level, which in principle is not subject to any form requirement. There are discussions. It's disputed if the validity of the opt-out agreement is to be assessed on the basis of the governing conflicts rules or of the forum or Articles 14 to 24 CISG. Probably the former is the better solution for this, because Articles 14 and 24 just relate to sales contracts, and the choice of the applicable law is the agreement is a different story. And there's a similar dispute regarding the interpretation of opt-out agreements. Is it subject to Article 8 CISG, or is that to be done according to the conflicts rules of the forum? In practice, of course, and we've heard that, I think, before, for the sake of clarity, the best way to opt out is a clear and express provision according to which the parties exclude the applicability of the CISG. The opt-out agreement doesn't have to stipulate the then applicable governing law if there is no specific indication as to which law shall apply. Then normal conflicts rules apply. But again, from a practical point of view, of course, it's better to to determine the applicable law expressly. The text of Article 6, of course, does not prevent an implicit exclusion of the applicability of the CISG. It's commonly accepted that this is possible, but there are debates, discussions, and the implicit opt-out arrangements between parties have led to many lawsuits and uncertainties, so an express opt-out clause is always preferable. I'm not going through all the different problem cases here because we want to save some time. But I want to make one point, following up on what Liu Jia has just said, and Wang Jiangyu as well. I think even in the current state, in the current situation, it's important for parties to have a clear contractual statement excluding or expressly confirming the applicability of the CISG. This is because, as Liu Jia has just mentioned, the government of the PRC has never made an express declaration according to Article 93, excluding the applicability of the CISG for Hong Kong. And that has led, as we know, to uncertainties, contrary to the DOJ's position. Other countries' courts have argued that the CISG is already applicable in Hong Kong. And Chow, if I may, I would therefore, I think your proposal to go forward to confirm the position of the CISG in Hong Kong with a diplomatic note is quite good, but it probably just has to confirm that it's actually applicable. It's a confirmation, in my view. Now, as summarized by the CISG, by the DOJ in the consultation paper, it's estimated that the CISG opt-out rates are significant in particular jurisdictions. The numbers are indeed impressive, but it's important to understand that these are only estimates. Furthermore, these numbers do not tell us what the alternative choices of the applicable law were in cases where parties have opted out. They also do not tell us how these opt-out rates compare with the opt-out rates in relation to otherwise applicable domestic law. That is, if the CISG opt-out rates are really higher than what we normally see, whether there are CISG specifics which cause parties to opt out. I'll get to that point in a minute. The numbers are stunning. The CISG has been called one of the most successful legal unification projects ever, and yet parties do not seem to, and their legal advisors do not seem to like the CISG. Before I get to the specific reasons why that may be the case, we have heard some of these already today. Let's just remind ourselves what the perceived advantages of the CISG are. The main one, obviously, is that the CISG achieves unification and simplification and facilitates cross-border sale of goods. It's state-of-the-art, and it avoids the choice of law process altogether within the scope of applicability of the CISG. Critics of the CISG, of course, argue that the CISG replaces well-functioning domestic contract law in a one-size-fits-all manner. It requires the implementation, the introduction of the CISG requires investment in time and money because parties need to familiarize themselves with the CISG. And it is being argued that the CISG leads to uncertainty because the implementation practice will need time to develop. The CISG is broadly formulated and it's a compromise. And of course, there are interpretative differences in contracting states. And this is reinforced by the fact that there are 6 authentic versions, language versions of the CISG. And of course, the critics point to the high opt-out rates. That's seen as evidence that the CISG doesn't work. And there are specific common law aspects, which I'm sure will be addressed in the later presentation on the UK experience. Now, in a perfect world, the parties to an international sales contract would consider the advantages and disadvantages of the CISG in a particular case and would make an informed decision whether it is beneficial to exclude the applicability of the CISG. Research conducted in relation to choice of law decisions in international transactions suggests that these decisions are all too often not taking this very rational approach. Decision-making processes are routinely influenced by cognitive biases and errors in estimations or odds, leading to irrationalities and scenarios whereby the contracting parties may simply pass over the better deal. The study which has led to this conclusion was conducted in 2014 in 93 jurisdictions with 228 respondents. The survey, the study was done to analyze parties' preferences in the international contract negotiation context. The study asked, amongst others, the respondents to declare whether they have opted out or of a particular national law or whether they have, or the CISG. And interestingly, the opt-out, the respondents' opt-out rate for national law was close to 60%, whereas for the CISG, it was only 33%. Now, we do not know why the CISG opt-out rate is lower, but this takes me back to the earlier point. that without further evidence, it cannot be assumed that the reasons for opting out of the CISG are CISG specific, and that CISG opt-out rates are really higher than opt-out rates in relation to otherwise applicable domestic law. The survey, which I have quoted, conducted by Gustavo Moser, followed up with a question about the reasons for opting out of the CISG, and 55% of the respondents gave reasons. I can't go through the reasons one by one, but there are a couple of observations that can be made. The first one is that the reasons are really diverse, and it seems very difficult to make general conclusions. Getting back to Professor Gary Bell's presentation, interestingly, I think Article 95 was not mentioned as one of the reasons. Or Article 11B. Second, the perceived general advantages and disadvantages, which I have just introduced, do seem to be only to a certain extent important for the decision of parties to exclude the applicability of the CISG. Here are other reasons that parties have mentioned. Third, the author of that study, Gustavo Moser, has pointed out that when answering the survey questions, respondents did make rational choices. They had time to consider, and it is unlikely that irrational factors, which may have determined real-life decisions, were considered also when answering the survey. But these irrational factors do certainly exist, and they do certainly influence choice of law decisions. In particular, lawyers are normally deeply attached to the legal notions with which they have been brought up and to which they are accustomed, as Professor McKendrick and his co-authors have set out in a book published in 2007. Furthermore, it must be acknowledged that nobody likes changes and everybody is risk averse. And when in the survey, the respondents argued that they had no experience with the CISG, then probably this simply meant that they wished to stick to the status quo because that was easier, and they didn't want to make a mistake. The use of standard contracts, which exclude the applicability of the CISG, may be driven by the same rationale. That is, parties don't want changes; they just want to stick to something which seems to be safe. Another irrational reason for excluding the applicability of the CISG can be time pressure. To make a rational choice about the CISG requires familiarity with the CISG. But studying and appreciating the CISG needs time, and lawyers don't have time except when the time is paid for by their clients. Fourth, some of the reasons given by the respondents of the quoted survey suggest that parties who opted out follow what they perceive to be common practice. Moser calls them the herd followers. And then there are also indications that some parties may have had bad experience in one case, which was then generalized and exaggerated. Now, but my personal view is that all these reasons will also apply in Hong Kong when the CISG, when and if the CISG is officially introduced. Why should Hong Kong be different? But it must be emphasized that the study that I have quoted included Hong Kong and mainland China, but it was not Hong Kong specific. And what must be asked is whether there are any Hong Kong specific reasons, especially legal, political, economic situation, cultural reasons, which will lead to a rejection of the CISG. We do not have reliable data. However, anecdotal evidence suggests that Hong Kong lawyers are particularly attached to the common law system, and anything that appears to be close, appears to have a civil law flavor, for example, because it comes in a codified version like the CISG, may not be welcome. And interestingly, this seems to be similar to what Professor Bell had mentioned in relation to Singapore earlier. And then there's the current political climate in Hong Kong, which may reinforce the idea, the insistence on the one country, two systems principle, which may cause lawyers to prefer the status quo and to reject the CISG simply to make the point that the current law is what they believe in. Finally, cultural reasons. Are there cultural reasons? I mentioned Hong Kong is a common law jurisdiction, but of course there are different cultural influences that we are seeing in Hong Kong. Having said that, I personally do not see how these cultural influences would lead to a higher or a lower CISG opt-out rate. Now, what does all this mean? I'm coming to the last part of my short presentation. What does all this mean for the application of the CISG in Hong Kong? For the reason I've mentioned, I believe that for at least 5 years, 10 years, or even longer, the official introduction of the CISG to Hong Kong, the exclusion of the applicability of the CISG will remain standard practice. But we also have to acknowledge that in this regard, Hong Kong will not be very different from other jurisdictions. Is this something which should prevent the official introduction of the CISG to Hong Kong? I'm saying the official introduction because I think there are good reasons that the CISG is already applying. I've mentioned that earlier. But is that something which should prevent the official introduction of the CISG to Hong Kong? I do not think so. As the DOJ has set out in the consultation paper, Article 6 CISG underlines party autonomy. It's for the legal profession to come to appreciate the advantage of the CISG in general and in particular cases. I want to be clear, I do not wish to propose that parties should never opt out of the CISG. But there may be cases where the CISG is probably not the best choice. But however, parties and their legal advisors should be able to make an informed choice by considering all factors concerned. Final question, is there a way to avoid high CISG opt-out rates in Hong Kong? Acceptance of the CISG can, of course, be improved through promotional and educational initiatives. We have heard about these also in other presentations. These would have to aim at familiarizing concerned parties with the CISG. In this regard, it may also help to point out that the unpopularity of certain laws can often not be rationally explained. Furthermore, as we have also heard already, it could be highlighted that irrational opt-out decisions, for example, just because there is no time to really study the CISG or because somebody is not familiar with the CISG, may even lead to professional liability. But at the same time, I think we also have to acknowledge that it's unlikely that any educational or promotional campaign will eliminate irrational choices, irrational choice of law decisions once and for all. Again, I trust Hong Kong will not be very different from other jurisdictions in this regard. Thank you very much.